So I'm going to grant the motion to suppress that the officer was not credible when the officer stated.
It's typical for you to not write reports when you're going ahead and handcuffing.
Hold up. That first line from the judge is a ruling, and it's a bombshell. He's granting the motion to suppress, which means key evidence against the defendant might be thrown out. The critical issue? Officer credibility. This entire case hinges on the officer's testimony versus the video evidence. Keep watching to see why the judge found the officer unbelievable.
People when asking them questions.
Could he have done that?
Well, would you guys have allowed him to? If he didn't answer the questions to your liking? He said, no,
His rights.
I was just checking.
As it was approaching me, it did have its high beams on, and it had 3 lights on instead of all 4.
That the alleged traffic offense of not having any functioning headlights is completely false.
If I go ahead and do that, are you going to come up with me and you're going to handcuff me? Because the officers went from 0 to 60 like in 3.2 seconds without the need and basis for it.
On first contact with you, and he was with you for several minutes, he never mentioned marijuana. The only time he mentioned marijuana is when he went to his car. He ran your vehicle the first time, then he ran it the second time after calling someone and saying that he needed PC on the vehicle. And are you Mr. Nevels?
Yes, sir.
All right. So yesterday we had a hearing on a motion to suppress. The officer was called as a witness, and you were also called as a witness. The state entered into evidence without objection, State's Exhibit number 1, which is a DVD of the stop of the vehicle and also the entirety of the interaction with the officer on the date of the alleged offense. And counsel, if you could give that to the court reporter so they can have it in their record, please. All right. The court reviewed State's Exhibit number 1 last night, and also I reviewed it again this morning to make sure. There's a lot of coming from that room. All right. The court reviewed it again this morning just to make sure that I had everything that I was looking for with regards to State's Exhibit number 1, and also with regards to both the testimony of yourself and of the officer. When looking at the DVD and bearing in mind watching State's Exhibit number 1, but also reviewing mentally the testimony of yourself and the officer, this is what the court finds. The stop was a legal stop. The stop was for speeding. On State's Exhibit number 1, you admit to going over the speed limit. The officer informed you of what the speed limit was. You informed the officer what you thought the speed limit was, but you admitted to the 47 miles per hour, and I believe it was a 30 mile per hour zone. Then the next question becomes, did the officer have a right?
This is a key legal point on the Fourth Amendment. The smell of marijuana alone often provides probable cause to search an entire vehicle. It's called the automobile exception. But here's the twist. The judge just laid out the rule only to spend the next 5 minutes explaining why the officer's claim of smelling marijuana is totally bogus. The defense's lawyer's earlier words about the 0 to 60 handcuffing pace are now hanging over this hearing.
To search your vehicle if the officer in fact thought that there was a smell of marijuana. The case law is clear. If there is a smell of marijuana, an officer is allowed to search the vehicle. They are allowed specifically to search the trunk if they so choose to search your trunk. In this case, they searched the trunk and they found what they believe to be illegal substances. So the next question for the court becomes whether witnesses are credible or not. What the court viewed in State's Exhibit number 1, and if someone is objecting to what the court viewed and what the court is about to say, what is in State's Exhibit number 1, please do not hesitate to let the court know. You're pulled over. You're at an apartment complex. You tell the officer that you are there to see your girlfriend. The officer discusses with you, as he has a flashlight looking in your vehicle, the reason for the stop, which was for the speeding, which you agreed you were speeding. The officer asks for your insurance and driver's license. You tell the officer that you have your insurance information on your phone, but you would like to speak with your girlfriend. The officer asks why you would like to speak with your girlfriend, and you state to him because, and I'm summarizing here, you state with him because your girlfriend was expecting you and you just want to let your girlfriend know what is occurring. The officer tells you not to do that. You continue to look on your phone for your insurance. You tell the officer, I promise you, I do have insurance, but I got the insurance online and I am looking for it. The officer continues to speak with you, and this goes on for several minutes. During that first contact with the officer does not mention whatsoever any smell of marijuana. The officer then leaves your...
This is a smoking gun. The judge is walking through the video evidence step by step. The officer didn't smell marijuana immediately. He went back to his car, ran the plate twice, and then made a call where he said, I need PC for this vehicle. PC equals probable cause. Pause and think. If he already smelled marijuana, why would he call for probable cause? Drop your answers in the comments below.
Vehicle and goes back to his vehicle and says he wants to check on something. The officer enters his vehicle, and there are phone calls that are coming into him, and he's making phone calls out. On his screen that is in his vehicle, it appears to the court that he is running the vehicle. The court is unable to view exactly what is on the screen because the writing is very small and the video is not great. But when he runs your vehicle, the court sees that there are green lettering throughout the screen. And he's clicking on a button. And as he clicks on the button, the screen continues to go to what the court is assuming the next page, and that is green. He remains in the vehicle. Another call comes in, and then either he sends a call out or a call comes in to him, and he lets them know what's going on. And he says in the phone, I need PC for this vehicle. Then once he requests PC for the vehicle, then I see the screen again, and all of a sudden the screen comes up with a bunch of red writing. The court is making an assumption because neither party asked what he meant when he said, I need PC of the vehicle. The court is assuming that that call was, I need probable cause for this vehicle. Then after he does that, he gets out of his car, comes back to your car, and he shines the flashlight on you again. And he says, why are you looking at Wells Fargo? And your response to him was, I'm looking at Wells Fargo because that's where my insurance comes out each month. I swear to you, I have insurance. He allows you to do that. Then he says something to the effect of, let me be honest with you. I smell marijuana in your car and you have this box. And you tell him that box is empty. He says, do you have any weapons or anything in the vehicle? Because I'm going to search your vehicle. And your response to him was, I have a samurai sword. Just as a side note, why you have a samurai sword, I don't know. But that's what you tell him. So then he says, well, I smell marijuana, get out of the car. I'm searching your entire vehicle. He takes you to the back of the vehicle. He proceeds to handcuff you and tells you you're not under arrest, but I'm doing it for my safety. Then he searches your vehicle. The court is going to find that the state's witness was not credible. And so I'm going to grant the motion to suppress, not based upon the fact that the search was improper or illegal. I'm basing it on the fact that the officer was not credible when the officer stated that he smelled marijuana in your car. And the reason for that is because on first contact with you, and he was with you for several minutes, he never mentioned marijuana. The only time he mentioned marijuana is when he went to his car. He ran your vehicle the first time, then he ran it the second time after calling someone and saying that he needed PC on the vehicle. The court is assuming that PC means probable cause to search, and he's looking for that and asking for them to give him PC. I could not understand or hear what conversation was going with whatever party he was on the phone with. But if he's asking someone for PC to search your vehicle, that means in the court's mind that he wasn't credible when he said he smelled marijuana. Anything else from either side?
No, Judge.
Yes.
The one with us, correct?
Oh, so he can either sit there or he can stand here, and I'll need you to move over there, sir. Hello. Hi, all right. If you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, in just one moment. Here you are. Don't hold it.
Thank you. Bad.
No problem. And as children, my grandmother would always say, "Don't swallow it. It's going to ruin your intestines." Don't know if that's true or not, but we don't.
Probably.
All right.
Officer, do you recall this video that was from your body worn camera?
Yes.
Okay. Let me ask you some questions, sir. Is riding a bicycle on the sidewalk a crime that is commonly associated with violence?
No.
Okay. What about failing to have a light? What about failing to have a light on the front and rear of the bicycle? Is that commonly associated with violence?
Not in my experience.
Okay.
But let me caveat that. No, that is not commonly associated with violence. However,
Thank you.
it is commonly associated with people who would flee from a traffic stop when they're pulled over.
Thank you for that response. Now you say that he failed to stop when you guys had initiated the lights first and foremost. Is that correct?
Yes.
Okay. Where is that listed in your report? Can I have that report for you if you want to furnish recall your memory?
Yeah.
Would you like
take
to
a look at this?
Yeah, yeah. If you
So
could
this is not my report.
Okay.
The handling officer is Officer Brown.
The defense attorney just exposed a massive vulnerability. The testifying officer, the one who actually made the physical contact, did not write a report. This instantly raises questions about accountability, procedure, and how the incident's details were recorded. The officer is essentially testifying from memory and the video while relying on another officer's unseen report. This is poor police work, and the attorney knows it.
Okay. So I'm covering this. This.
Okay. Did you do a report as well?
No.
Okay, you did not do a report with regard to this. Okay. So information on here, if it didn't have where he had taken off or had to try to evade, that just didn't make it to the report. Is that what you're saying?
I didn't write this report.
Okay. When you approach and get out of the vehicle, is my client trying to evade or trying to get away from y'all in any way, shape, or form?
No, sir.
Okay. And you said you had additional officers with you, correct?
Yes, there's two of us there.
And to the best of your recollection, my client was alone, was he not?
Yes, sir.
Now, the way that you went about arresting him was quite quick, wouldn't you say?
Objection to the defense's characterization of this is an arrest.
All right, that'll be overruled. You can ask your question.
Placed in handcuffs.
I'm sorry, you're asking if it was quick?
Yes. Do you feel like a lot of time had elapsed between you getting out of the car and you handcuffing my client?
I feel like an individual is detained in a reasonable amount of time that could save for both ends.
Did you feel that the amount of force was necessary?
Yes,
And why did you feel that amount of force was necessary?
the amount of force. The individual was removed from the bicycle. To the best of my belief and knowledge, he didn't incur any injuries, and he was placed in handcuffs.
Is that the way you go about doing investigative detention upon stopping people in the streets, is the accosting and handcuffing them?
No, the individual accosted and handcuffs. No, he was being stopped for a city ordinance violation, and based off of my experience, when they don't immediately exit the bicycle or come to a complete stop, oftentimes they're fleeing or they're considering fleeing. And it's a safety hazard for both us and them.
So going back to the city ordinance issue, when you see someone violating a city ordinance issue, say, for instance, jaywalking or maybe riding a bicycle on the sidewalk, do you cuff him and place him in custody and question them like that?
Objection, relative.
Overruled.
Say, for example, let me simplify it for you a little bit. If I was walking across the street and I jaywalk, say I don't wait for the crosswalk to happen. I mean, it occurs all the time.
The jaywalking hypothetical. The attorney is brilliantly using hyperbole to attack the officer's justification of force. Riding a bicycle on the sidewalk, a minor ordinance violation, is being treated like a major felony arrest. The core legal argument here is the difference between an investigatory stop, detention, and an arrest, custody. Handcuffing drastically pushes an interaction toward an arrest, often triggering the need for a Miranda warning before questioning.
Right here on this four-way stop over here in front of the courthouse. If I go ahead and do that, are you going to come up with me and you're going to handcuff me and then go and ask me questions at that point when I'm already handcuffed? Or are you going to talk to me real like as an actual person and try to delve and see what's going on?
It's all dealt with on a case-by-case basis. So, and you're indicating the area in front of the courthouse, which is not the area I work. I don't know anything about this area.
I'm saying hypothetically, yeah.
Hypothetically, I don't work this area and I don't know anything about it.
Okay.
So I work south. And in that area, at the time of day, the location we were at, the area he was leaving, known for narcotics pickups and deals, his behavior, all of it added up to multi-factors to our actions.
So you said he was leaving a gas station, right?
He's leaving a gas station area.
Gas station in the area. So couldn't he have easily just been getting a soda or
Absolutely.
or some chips?
Absolutely.
And you're coupling that with the fact that he was on a bicycle to try to justify the fact that you're just handcuffing him without doing any kind of questioning before that fact?
No. The reason that he's being handcuffed is, once again, the length of time it took for him to come to a stop after the emergency lights were activated and him not immediately exiting the bicycle.
And you heard in the video that he says he didn't really see you guys. Did you not? Like in the video, he says, I didn't even know what's going on. I didn't see you guys. Maybe possibly he doesn't see that point because you're saying this happened, but where is that listed in your report?
Again, I didn't write a report.
So is it typical?
The handling officer wrote the
Is it
report.
typical for you to not write reports when you're going ahead and handcuffing people and asking them questions?
For cover officers on most every call, no, they don't write reports.
But you're the one that actually handcuffed him, took him off his bike, put him against the car, and started questioning him, correct?
I'm the one that first made contact with the individual, and both myself and Officer Brent Vermeulen detained him, the handcuffs, and then began questioning him.
So that gets me to another point. You relayed information to the other officer, or the other officer made a report stating all these facts. Is that what you're saying? Or you have no knowledge?
No, what I'm saying is that Officer Brent Vermeulen and I were both partnered up at that moment.
Okay.
And we both initiated a traffic stop together, which is common for officers around the city and other departments to take calls together, make traffic stops together. And at the time that we detained the individual, we started working it from there.
But you were the person or the officer that got out of the car and then handcuffed, correct?
As it appears on the video, it looks like I made contact with him first, but Officer Vermeulen was right behind me.
Okay. And who asked the questions of the defendants?
Both of us asked questions.
And you didn't feel like the need to do a report just to cover your basis in terms of the handcuffing and the questioning?
When it comes to traffic stops that result in an arrest, there's a handling officer and then there's cover officers outside of that. There's some cases in the department where a supplement report is required, and that's usually dictated by a supervisor. In this case, it's just a simple one officer is handling the report and the other officer is covered for safety.
Did you witness my client do a hand-to-hand with anybody?
Not that I remember, no, sir.
Did you witness him committing any other infraction besides having the city ordinance of having the bicycle on the sidewalk or not having the lights? Did you witness any other kind of criminal infractions?
None that are coming to mind right now.
So there were two of your officers and just my client, right?
Yes.
Couldn't you have requested that he get off of the bike. He gets off of the bike. You're questioning, or he's questioning, and then the other officers maybe keeping an eye out for safety. I mean, couldn't that have happened instead of what happened on the video?
What happens commonly in the traffic stops is when we initiate our emergency lights. Most people in society have gone through some form of driving school, driver's ed when they're in high school, and it's covered in that program that people are to pull over when they're being stopped. And when they don't do that, we at that point start to take guesses as to why. Either they're not seeing us, or they're refusing to pull over, or there's something inhibiting them from understanding the situation. There's all kinds of reasons why he might not pull over.
But again, as far as we can tell, since you didn't do a report, it's not documented on your end, and you don't know what the other officer documented on his end, do you?
The documentation on my end is on a video in front of us, both my body-worn camera and then the video attached to my vehicle, and then the handling officer wrote a report.
Documentation usually refers to written correspondence rather than video, does it not?
There is video documentation and there is written documentation.
In this instance, there was no written documentation as to a report.
No, there's written documentation. It appears like it's right here.
That you wrote, though.
No, sir.
And you're maintaining that that type of force that you used was reasonably necessary to effectuate the goal of seeing why he was riding on the bike on the sidewalk, or that reason why he didn't have the lights on. Because did you charge him with evading on foot or evading on a bicycle? I'm just curious.
I'll go to your first question. Do I think the force was necessary to affect him being detained? Yes. And he was detained at the moment that the emergency lights came on, and we completed him being detained at the moment that the handcuffs were put on this person.
Would you agree that if a person is cuffed and the situation went how it went by, where everything happens really fast, that objectively speaking, he may not have had the whereabouts of whether he could leave or not, or the know-withal that he could leave, or the freedom to leave? Did you feel like you restricted his freedom?
I'm not understanding your question.
The way that the video is portrayed, where it just gets out, really no verbal dialogue, it's just taking and restraining the person. Could it be seen objectively that he didn't believe that he could leave at that point in time? Could he just walked away at that point in time after you cuffed him?
At the moment that the traffic stop was initiated, he was not free to leave. And most people, again, who have gone through some form of driver's ed understand that they're being detained at that point.
But I was asking about the moment when he was handcuffed.
The moment that he was handcuffed, yes.
Do you believe like he could
A reasonable person would believe that he was not free to leave at that point.
So he could have just taken off down the street, handcuffed and all?
Could he have done that?
Well, would you guys have allowed him to? If he didn't answer the questions to your liking, he said, no, I just want to go ahead and assert my constitutional rights to not speak to you. I want to go ahead and just walk down the street with, would you guys have talked to him at that point, or would you guys just continue the way that you guys had continued?
At the moment that the traffic stop was initiated, he was detained, and at that point, he was not free to go.
Okay.
If at any point during the stop he had left, no, he would have been solely.
Yeah, so he probably couldn't have gone at that point. Did Mr. Evans, was he cooperative with you guys? Like when you guys were talking with him?
After we made physical contact with Mr. Evans, he was very cooperative.
Did he submit to your show of authority?
I'm not understanding.
Did he submit to your show of authority, like you as the officers?
Can you define a show of authority?
You as the officers handcuffing him, placing him in custody. He didn't resist or anything like that, did he?
Did the individual resist after he was placed into cuffs? No, I don't remember him resisting after he was placed in cuffs.
And then the show of authority is more like he was following your y'all's request, and he was cuffed, and he didn't really feel like he was free to leave at that point because you guys had him cuffed. So what was the time frame between you cuffing and handcuffing and taking Mr. Evans to the car and asking him questions? What was that time frame like? Was it large amount of time? Was it a short amount of time?
As viewed on the video, I would just describe it as a reasonable amount of time. And to me, in my experience, this is y'all use the word quick. I I don't see this as quick. I just see this as resolved.
As resolved. Do you think it could be resolved in another fashion?
It could be resolved in any fashion, just based off of our own observations, what we have in front of us, and based off of his actions,
Right.
based off other people's actions.
Or perhaps communicating with people before such action is taken of a coercive nature to handcuff someone and restrain them of their liberty. Communication could be key, correct?
Based off of the video that we all just watched and based off of my memory as well, I advised him to exit the bike multiple times prior to.
Okay, well, I must have not have seen that. Let me go ahead and replay the video. Continue playing the video. You said that you asked him multiple times to get off the bike before he got off?
Say, get off the bike, get off the bike.
Okay. Did you allow him the time to get off the bike, or did you guys just swarm him? Okay, where did you allow him time to get off the bike? Is my question to you.
During the time that I was saying get off the bike.
Get off the bike as you were grabbing him, throwing him off the bike and handcuffing him. Is that what it was?
I don't remember throwing him off the bike, and I don't see throwing him off the bike.
Okay, well, you grabbed him, tear him off the bike. You could have asked him to step outside of the bike. Sir, you're aware that you're violating a city ordinance. Could you have gone about it that way?
There's many options on how we can detain somebody. Again, with what I have in front of me, based off of my experience, the last thing I want is for any person to flee from us and still on a bicycle, and that can travel faster than foot speed for both me and my partner. And the last thing I want is for an individual to end up getting hit by a vehicle or to put themselves in a situation where they're going to get hurt or we're going to get hurt.
And you reference detention. Are you aware that if more force is necessary to effectuate the detention, it could turn into a custodial interrogation if questions are asked?
If more
force is necessary to maintain the status quo or to effectuate the reason for the stop, if more force is used more than that, then it could, you taking someone in custody or handcuffing someone could be viewed as the objective standard is taking someone into custody. Are you aware of that provision of the law?
Yes, and I don't think that more force than was necessary to affect the detaining and handcuffs was used here.
But that's your opinion. That's your subjective opinion, correct?
Sure, absolutely, yeah.
So once he was taken from the bike and handcuffed, you guys started asking him questions, did you not?
After the individual was placed in handcuffs, yes, he was asked questions.
Okay. Did you read him his Miranda rights at that point in time?
Don't know how deep we got in the video. I don't remember reading his Miranda rights at that moment.
Do you know if the other officer read the Miranda rights? So you're not sure if Miranda rights were ever read in conjunction with the statements he made after he was placed in handcuffs?
Correct. In conjunction, meaning like what are you saying?
Like after he was placed in handcuffs and asked questions, you're not sure if he was Mirandized or not.
I'm not sure if Mr. Evans was Mirandized at any point.
And again, that probably would be useful if there was a report written, but you're saying you never wrote a report, right? Just to clarify.
Again, the handling officer wrote the report, and whether he was Mirandized or not is on the handling officer because he's making the arrest on paper.
No further questions, John?
Right, state? Yes.
When you activated the emergency overhead lights on the school here, did that indicate that you intended to detain a person?
Yes.
So that is a show of force.
Yes.
And did Mr. Evans respond to that show of force?
Mr. Evans' response to the activation of lights was to keep rolling on his bicycle.
Any further questions? Any further questions?
No, from the defense, Judge.
All right, is this witness excused?
Say yes.
Yes, Your Honor, from the defense.
All right, thank you. State, any further witnesses?
Good.
Defense, any witnesses?
No witnesses, Judge, just the justification.
All right, the court will hear a brief argument. State. I know it's defense's motion, but I'll have you proceed first.
The only comments that I really need to make are contained in Rose's statement, which is a decision by the Court of Criminal Appeals from 1997, which I provide copies to the Court of Defense.
Okay.
But essentially,
The state is fighting back with a reasonable officer standard, arguing that the cop's actions must be judged in the moment, not in hindsight. But the defense's argument is sharp. 2 officers against 1 cyclist for a bicycle violation. The immediate cuffing, the lack of report, and the questions asked while detained all point to a custodial interrogation without the required Miranda rights. That's why the judge sided with the defense in the earlier clip. And that's the powerful legal lesson here.
the Court of Criminal Appeals ruled that reasonableness under the Fourth Amendment, while not capable of precise definition, must be judged from the perspective of a reasonable officer at the scene rather than manage a bicycle. And furthermore, allowances must be made for the fact that officers must often make quick decisions under tense, uncertain, and rapidly changing circumstances. Now, defense counsel asked quite a few questions about hypothetical situations in which Officer McFadden may find himself in other environments, but we're not talking about hypothetical situations in which he may find himself. We're talking about the actual situation in which he did find himself, the actual circumstances, the actual environment, the actual conduct of the defendant, none of which was rebutted by defense counsel. So considering the time of day, the area, Officer McFadden's personal experience on that patrol, the actions of the defendant in response to a show of authority, it is reasonable, it was reasonable for the officers to detain him in handcuffs, given the circumstances, and detaining him in handcuffs was a reasonable use of authority and force at that time that did not rise to the level of an arrest for which Mr. Evans needed to have the custodial warnings recited to him before his statement, his inculpatory statement, would be admissible in use against him at further proceedings, and as a result of which evidence was discovered. That's all.
All right, defense.
Thank you, Your Honor. In relation to this matter, Judge, simply, he wasn't charged with anything else. He was not charged with resisting. He was not charged with evading. The reports don't even mention any of this. And he's trying to point to an officer, and the officer may have done it. The officer's not here, and this officer did not do a report. I do have a report here, and there's no mention of any kind of conciseness of what the basis was of them needing to handcuff him. They were 2 officers there, Judge. You saw my client was not making any furtive movements. He was not trying to take off on the bike. They grabbed him immediately, placed him into handcuffs. And in my opinion, that amounts to taking him into custody, because the officers went from 0 to 60 like in 3.2 seconds without the need and basis for. Miranda is there just to safeguard these things about coercive nature of police interactions and a person being informed of their rights before they can actually consent and agree to a search or agree to remain silent. My client was taken, pulled, thrown into the front of the car, and was not admonished as to his right to an attorney, his right to remain silent. The officer says that he didn't believe that he could walk away. Being in custody is based upon numerous factors. It's based upon the nature of the crime under investigation, which is for an ordinance of riding a bike on the sidewalk. This, in my opinion, was the officers targeting my client because they saw him as an easy target, a way to justify some stops, a way to justify some arrests. Also, the reaction of the suspect can also be determined as to when the officers roll up on him. He doesn't try to take off like I just stated. So there was really no need, in my opinion, for the officers to go about this the way that they did. They could have asked him, "Sir, please get off the bike. Do you know what I'm stopping you for? You're in violation of this ordinance." And then they could have gone about investigating if they believed that there was other drugs or if there were other things going on.
So your argument is you're not arguing about the stop. You're arguing about the fact that he was placed, you're arguing that he was in custody.
Yes, Judge. I'm arguing that he was under custodial interrogation. The officer, in my opinion, he did, albeit petty, a reason to stop my client in violation of an ordinance. So we're not attacking or we're not challenging the reasonable suspicion.
So you're saying that when he was, you're saying he was taken into custody, that he wasn't Mirandized. And during that time, is that when there was an admission of drug possession?
That is correct, Judge.
And so you're saying that the statement was not properly obtained, and
Yes.
anything else that follows from there should be suppressed.
That's exactly right.
Okay.
Yes, I'm sorry for not clarifying that. First, it's just we're contending that the force utilized exceeds the reasonable force necessary to effectuate the stop and to maintain the status quo. That's the way the courts have held that it can be transformed based upon a totality of circumstances and objective nature about how things were done. And if the way that things were done, the abrasive nature of my client being taken off of the bike, handcuffed, and then questioned without being Mirandized, is a violation of his due process rights. That he was, because if he was made aware that, hey, okay, I'm actually cuffed, they're actually looking into me, I need to maybe keep my mouth shut, or maybe I need to have an attorney, he could have made that request, but that was not made available to him.
Okay.
And all this happened within a span of like 5-10 seconds, as you can see from the video.
Okay. Then I understand both parties' arguments. State, I understand your argument. Defense, I understand your argument. What I will do is I'll review the video, and I'm familiar with both of the case law that you all have presented to the court with Rose and also with your case law, but I still like to reread case law, even though I'm familiar with it. So what I'll do is I'll have you all come back tomorrow.
Judge, I'm going to be out on leave tomorrow,
All right. So when will you be back?
the 19th and after.
All right. So what I can do is, where are you going to be tomorrow?
I'm going to be out of state.
Okay. So what I can do, I can do one or two things. One, I can send you all an email with what my proposed ruling will be.
Okay.
That way both parties will know.
Yes, Judge.
And that way, if I were to rule in the defense's favor, which I'm not saying I will or I won't, then your client won't be held over if I were to rule in your
Oh,
favor.
great. Yes, I'd be amenable to that email correspondence. It is.
You tell me tomorrow morning if I do rule in favor of defense counsel office and motion to dismiss.
Okay. All right. So, and I'll send. All right. So I'll send you all an email to let you know.
Okay.
I just want to make sure I review the video, review each of your case law again, and then I'll let you all know what my decision is going to be.
Sounds like a printed copy of the case.
Yes. Thank you. And then, Norma, if you can have Mr. Evans brought over tomorrow. And Mr. Evans, I'll let you know what the ruling is as well.
Can you excuse my language? They scared the hell out of me.
No.
Language
No.
is pretty.
All right. So we'll recall it for tomorrow.
Thank you, Your Honor.
Thank you.
And,
You're a nice judge.
All right. Thank you.
I'll be available, Judge, and should someone need to be here from my office to cover, I'll make those arrangements as well, whatever the court needs.
All right. So my understanding, we have a verdict in the case. So I'm going to do this plea very quickly. And then everyone else, after I give them the verdict, will bring your client back out. So who is here on Dominique Escobar?
Under Texas Penal Code 3804, that talks about evading arrest or detention. The code states that a person commits an offense if he intentionally flees from a person he knows is a peace officer or federal special investigator, attempting lawfully to arrest or detain him. The added burden that the state has given themselves this morning is that the indictment says, and I'm paraphrasing, a person the defendant knew was a peace officer who was attempting lawfully to arrest and detain him. So the state has to prove beyond a reasonable doubt that this officer had to arrest and detain the defendant. Number one. Number two, Your Honor, you'll see from the video that at no point in time was Mr. Jordan Davis doing anything remotely coming close to evading arrest or detention. Not even fleeing. You'll see from the video that at all times, Mr. Davis was driving either at the speed limit or below. He wasn't weaving within traffic. He wasn't causing any accidents. He wasn't turning off his lights or causing a high-speed chase. At one point during the follow, Your Honor, Mr. Jordan Davis goes so much as to turn on the hazard lights to let the officer know where he's at and that he's looking for a place to park. And this is important because you'll see in the video that during the 2 miles that the stop is being Mr. Davis is trying to find for a safe place to stop, he's in a construction zone. He's not going, or he doesn't stop in an area that's safe to him. He eventually stops in an area that is safe, well lit, and away from traffic. It may not be to the officer's liking that it took him 2 miles to stop, but nonetheless, at no point in time was Mr. Davis doing anything remotely close to fleeing. He wasn't doing anything remotely close to evading arrest or detention. The evidence will show the court that, again, Mr. Davis wasn't speeding, wasn't weaving, he wasn't driving while intoxicated, he wasn't dashing in through traffic to avoid the officer. He was simply looking for a safe, well-lit place to stop, which he did.
All right, State, call your first witness.
The 4 headlamps, is that correct? Now, which transportation code are you referring to when you're talking about the 4 headlamp
Require the transportation code 547, which would be the maintenance of the equipment. Specifically for the headlights would be 547.333, which is turning off your headlamps off from the brightness 500 feet upon approaching other vehicles.
Wait, but let's go on a second because you're jumping the gun a little bit. Your reason for the stop, and according to your testimony, was that my client did not have the 4 headlamps, right? So, and we'll get into the brights in a little bit, but your testimony was that he had 3 functioning headlights, correct?
Yes, sir.
Now, are you familiar with Transportation Code 547.321?
Yes.
Okay. 547.321, correct me if I'm wrong, states that a motor vehicle shall be equipped with at least 2 headlamps. It doesn't talk about 4 or 3, just 2, right? And in Mr. Davis's case, he had not only 2, he had 3 functioning headlights, right? Hold on, we'll get there in a second. Okay. So now that we know he has 3 functioning headlights, okay, your testimony is that you did a U-turn. So in other words, your dash cam recording of these 3 functioning headlamps is not on this dash cam, correct? Did you not record that?
From the way our dash cam is mounted, there's only 2 ways to activate it. That's by turning on our emergency lights or reaching over, which is across from my computer, and activating it manually.
I get it, but very simply, that wasn't recorded, right? Okay, all right. Now, if you look at this video, right here, Officer Enriquez, you told the court that as you drove parallel to my client's car, you were checking to make sure that my client had what he's supposed to when somebody is driving, right?
Yes.
So you correctly stated that my client had a seatbelt on, right? I think you told the court that you ran his license plate, right? And there was no warrants coming out for him, right? The car rightfully belonged to Mr. Davis, right?
Correct. I believe it belonged to family members.
Family members. Okay, but it wasn't identified as a stolen vehicle.
Correct.
Right? According to you, the backlights or the tail lamps to you were working just properly, correct?
Yes.
Okay. And so at this point, I think you also indicated that while you're parallel to him, Mr. Davis is not exceeding the speed limits, correct?
Correct.
He's not weaving in and out of traffic, right? He certainly does not almost hit you or caught you.
Correct.
Okay. All right. Now, starting the video at 2 seconds, now I'm going to try to jump to the parts that the state asked you about. Stopping the video at 1:47 seconds, Officer Enriquez. This is, according to you, a shopping center to your left, correct, right? And this also is to the left of the defendant's car, correct, right? Now, you agree with me that at this point, this area is still considered a construction zone, right?
Not that immediate area.
Not that immediate area. But the area before it was construction zone?
Yes, correct.
Okay. And so to the right of your car, which is also to the right of my client's car, there's nothing but dirt road and no lights.
Correct.
Right? So starting the video at 1:47, I'm stopping it at 2 minutes and 46 seconds. Officer Enriquez, I may have gone a little bit too far on the video, but again, to your left and to my client's left, we have, is it a car wash or a school?
No, that's a school.
That's a school, okay, so we passed the car wash,
Yes,
right?
sir.
So the school, car wash, the shopping center, all these three locations were to the left of your vehicle and to the left of my client's vehicle. To the right of the vehicle, we see nothing, right of my client's vehicle, or your vehicle, we see nothing but dirt road and grass and areas that are not well lit or not able for somebody to park, right? Officer, I'm gonna show you or hand to you what's been marked as defense exhibit number 1. Are you familiar with this?
Yes.
Okay, what is it?
Texas driver handbook.
Okay.
I'm sorry, could you repeat the last part? You said Texas, and then I didn't hear the second.
The Texas driver handbook.
All right, thank you.
In the Texas driver handbook, is it published by the Texas Department of Public Safety?
Yes, it is.
Judge, may I approach the state?
Yes,
Judge, while the state confirms that that document is what it is, can I continue my questioning of
yes.
Officer Enriquez? Okay. Officer Enriquez, while the state continues to review that document, up to this point in the video, at minute 246, at this point, you have.
Defense exhibit number 1, that is the Texas driver handbook.
Judge, under 8038.
No. Is it the Texas driver handbook?
It is, Your Honor.
All right, the state's objection will be overruled. Are you seeking to admit that into evidence, or you are just asking him to review it for demonstrative purposes and for the court to take note of that as you would a treatise?
Judge, I'm going to ask him to read from it, but to address any concerns, under 8038, it's a hearsay exception, and under 9025, it's self-authenticating.
Yes. Yes.
Thank you, Judge. Okay, Officer Enriquez, so I'm going to show you defense exhibit number 1, particularly.
And state if you need to move around to view what the defense is showing the officer, you're more than welcome to.
Particularly page 65, that talks about what a driver should do when stopped by law enforcement. Do you see that? Okay. So, and I'm going to read it to you, okay? It says, if you, the driver, are stopped by law enforcement, it is suggested you, number 1, slow down and move the vehicle safely to what side of the road? The right side of the road. All right. So the school that's on the left, car wash that's on the left, shopping center that's on the left, none of these locations are on the right side of the road, right? What's on the right side of the road is nothing but dirt, grass, and places that are, from a plan's perspective, are not safe to park, correct?
In his perspective.
Okay. Number 2, park your vehicle as far to the right of the main traffic lane as possible. Again, to the right, not to the left. So you were asking my client, because he did not go to the left, you're asking him to go against this Texas driver's handbook.
No, I'm just saying there were places that he could have stopped at, along with the shoulder on the right-hand side of the road that we went across all the way to Courtroom.
But according to this Texas driver's handbook, it only says to move to the right and park to the right, right? It says, if available, park on the right shoulder, right? If unavailable, park on a nearby, well-lighted side street or parking lot away from high volume traffic.
Which he did pass.
Right, okay. So, starting the video at 2:46, one thing I forgot to ask you, so at this point and for the remainder of the stop, my client turned on his hazard lights.
Correct.
Right? So turning on hazard lights is indicating to you, hey, I'm in front of you, be careful, I'm right here. Don't run into me, don't crash into me. He's warning you and other drivers, I'm right here, right?
Yes, sir. And I
Okay.
had my lights activated.
All right. At any point during the stop or the follow-up to the traffic stop, did my client turn off his lights?
No, he didn't.
At any point, did he speed up in excess of the speed limit?
No, he didn't.
At any point, did he weave within traffic to try to avoid you?
No, he didn't.
At any point during the stop, did you see him throw anything outside of the window?
No, he didn't.
So while he's following you, while you're following him, you're following not only the car that's right in front of you and never moved or never fled from you, but he also has his hazards on, right? Is that right, sir?
Yes.
Starting the video at 2:49. Now, popping it at 3 minutes and 1 second. if you can see from the video, it's a little bit blurry, but we see that my client is still driving within the lane, and to the right of it, there's what, a sidewalk,
The bike lane.
a bike lane?
Yes.
And then next to that bike lane, what's this cement-like structure that's on the road?
It's the sidewalk before that self-storage.
Okay. Starting the video at 3:02, stopping the video at 3:23, and the 20 seconds that have left, Officer Enriquez, again, we still see the bike lane that you're talking about, regarding the vehicle, and also the cement sidewalk to the immediate right, that bike. Right,
Yes.
that's making it, I guess, unable for my clients to park, correct, with the sidewalk. Starting the video at 3:23, and my client is still in front of you with his hazards, notifying you where he's located.
Yes, sir, in the center reading now.
Now stopping the vehicle, or stopping the video, excuse me, at 3:57, my client goes to his right.
Correct.
Right, to essentially make a right lane, right? Now, what did we say is on the Texas Driver's Handbook? When stopped by law enforcement, it tells the driver to what, slow down? Fortunately, with my client, he slowed the vehicle down, right? And then he moved to the right. Is that correct? And it was done in a safe manner, because there was no accidents, right?
Correct.
Certainly did not hit sidewalk.
Correct.
Stopping the video at 4:28. So after he slows down and makes a right turn, Officer Enriquez, my client comes to a stop on this road, correct?
Correct, yes, sir.
What's interesting to note, Officer Enriquez, correct me if I'm wrong, is that there is no traffic on this road, right?
Correct. There was that big two vehicles that did pass.
Okay.
They had to go around. They were blocking the number 2.
Okay. But at this point, because there's no vehicles here at 4:28, right, it's safe for not only the driver, but safe for you to get out of the car, right?
Yes, sir.
And then my last round of questions, officer, is at this point in time, I need to testify to the court that when asked, or when my client was asked by you to identify himself, you had no problem with him identifying himself and then following the order. And the lights, your car's headlights were on, and also, is it your spotter light, what do you refer to that?
Definitely.
Floodlight?
Yes, sir.
Yeah, that was on as well, right? Okay. And then the car that you talked about, right, that other car was to the left of you after, or to the left of that median dividing your roads, correct?
Correct. There was also a car reading behind us as well.
And then at 4:37 for the video, you see my client taking what appeared to be his 2 hands out the car, right?
Correct, yes, sir.
No further questions, Judge.
Any,
Nothing further, Judge.
all right, any further questions for this witness?
Not from the state,
All right, is this witness excused or subject for recall?
Excuse Your Honor, Autumn Panorama.
All right, thank you so much for coming in. You may step down. All right, state, call your next witness. Defense, do you have any witnesses?
No, Your Honor.
All right, so what I'm going to do, counsel, I know you have federal court. Counsel, we can go off the record. Are you all able to come back tomorrow? You want to come back this afternoon? Because I would like to view the state's exhibit.
Judge, I'm good coming back tomorrow if it's okay with the court, so
Yes.
not be in a rush to
All
pin the
right.
docket and then look at this video.
All right, so what, yes.
I'm here in the city of Lefkingham.
Thank you. All right, so what we'll do, Mr. Jordan, we will come back tomorrow. And if you will be here at 9 a.m., that way, this evening, I will have a chance to review State's Exhibit number 1 in its entirety. And then I'll come back with my decision.
Yes, ma'am.
All right, is there anything else?
Not from defense counsel, Judge.
All right, thank you so much for dressing appropriately for court. And State and Defense, do you all both rest and close? State,
Yes, Your Honor.
Defense?
Rest and close, Your Honor.
All right, thank you so much. All right, once you sign the reset form, you're excused. You're welcome. And everyone, we will be back at 1:30-ish, so everyone can get their break. Court is calling 2024 CR 5244, State versus Jordan Davis. Do I have parties announced for the record for the state? Defense?
Good afternoon, Judge. Alfonso Cabañas for Mr. Jordan Davis.
And are you Mr. Davis?
Yes, ma'am.
All right, you all had a bench trial with the court, and the court, after both parties had rested and closed, the court asked for an opportunity to view State's Exhibit 1 in its entirety. The court did have a chance to review State's Exhibit 1 in its entirety, so the court will hear closing arguments. State?
Your Honor, does the state typically not give closing arguments in trial following the defense?
If they want to. My understanding from speaking with you off the record that the defense didn't really want to do a closing. So that's why I was asking you for your closing. But if that's
I don't know whether defense counsel wanted to or not. But
all right, defense, do you want to get closing?
Yes, Your Honor.
Okay, then I'll hear your closing.
Thank you, Judge. Judge, as the court was aware during cross-examination a couple of days ago, the only officer that stopped Mr. Davis testified that the alleged traffic offense, that he saw being committed was not recorded. I asked him when I talked and described as to the reason for the stop, he initially said, well, his headlamps were turned off, or he didn't have the number of requisite headlamps as per the transportation code. When he confirmed on the stand that as per the transportation code, my client had more than two, he had 3 functioning headlamps, so much so that during the video, if the court recalls, the officer testifies that the headlamps in my client's car were working. Therefore, Judge, we have testimony from the officer that the alleged traffic offense of not having any functioning headlights is completely false. Secondly, Judge, after we move on from that point, the officer goes on a narrative in which he's trying to tell the court what he, the officer, would do in this situation. The transportation code and the penal code don't read that way. The transportation code and the penal code read that my client or the individual who is alleged to have been committing an evading offense needs to be clearly shown as evading law enforcement. If the court recalls from the video, during the entire length of the officer following my client doesn't speed, doesn't turn off his lights, does not drive in excess of the speed limit, does not drive under the speed limit, does not avoid traffic, does not flee from the officer. Additionally, my client goes so much as to take the extra step and notify the officer by turning on his hazard lights. The officer makes it a point to say that there were multiple shopping locations or shopping centers on the left side of the highway in which my client could have turned. Well, Judge, then I questioned the officer on Texas DPS, the driving manual, which states that when being followed by law enforcement, a driver has to stop, or rather must go to the right and stop in a place that's well lit and safe, not only for himself, but law enforcement behind him. So when I questioned the officer as to whether or not my client could have stopped on the right, being that it's a construction zone, being that there was nothing but grass and dirt and it was not lit, the officer said, well, I don't know, but I could have stopped there. As we proceed through the stop, or through the video, Your Honor, again, you continue to see that at no point in time did my client commit any additional traffic offenses other than the alleged traffic offense, which again was not recorded. The officer testified that my client was driving a vehicle that was not stolen. He was driving a vehicle with a seatbelt on. There was nothing that my client was doing as he was driving that warranted a traffic stop. As the officer continues to follow my client with his hazard lights turns to the right as he should, and then parks in an area where the officer testified there's no cars coming back and forth, thereby making it safe for my client and law enforcement to continue this interaction. And so the point of this, Your Honor, is that at no point in time did my client evade any arrest or detention. My client simply drove to find a place to stop. We know that he did not flee. We know that he didn't even intend to evade arrest or detention. He was simply looking for a safe place to stop. And as he was doing so, he notified the officer behind him by turning his hazard lights and maintaining a safe rate of speed. And for those reasons, Your Honor, I ask the court to find my client not guilty of the offense of evading arrest or detention.
All right. State.
Defense counsel's arguments are well made, but at certain points logically inconsistent and at other points irrelevant. Mr. Cabañas points out that the deputy's testimony was that Mr. Davis had 3 headlights on. Now, if Mr. Cabañas means this to mean that the high beams were on, then Mr. Davis committed an offense by having his high beams on within 300 feet of oncoming traffic. In which case, Mr. Davis committed an offense of the transportation code.
Was there oncoming traffic?
There was, Your Honor. And
Okay.
we'll be able to see it from the officer's dash cam recording. So Deputy Enriquez did have reasonable suspicion to detain the vehicle. Moreover, case law is clear. Under Lopez v. State, the Court of Appeals for San Antonio stated that although the officers agreed that Lopez was not accelerating from them or driving recklessly after exiting the highway, fleeing is anything less than prompt compliance with an officer's direction to stop, and fleeing slowly is still fleeing. So the fact that Mr. Davis did not speed or travel under the speed limit, the fact that he did not weave in and out of traffic, the fact that he was wearing his seatbelt, these are all very interesting assertions, but they are not relevant to the court's determination of whether he evaded arrest or detention. Finally, there's been no evidence introduced that Mr. Davis was actually following the Texas DPS handbook. There's been no evidence introduced that he's ever read it. There's been no evidence introduced that he was even vaguely aware of it. And so Mr. Cabañas' reliance on this Texas DPS handbook is misplaced because there's no evidence that Mr. Davis was actually following its advice. Even if he were, there were multiple areas for Mr. Davis to stop. The area in which he stopped was not a well-lit place. Deputy Enriquez testified that after the vehicle came to a stop, other vehicles had to go around it. And it's because where Mr. Davis stopped was on a 2-lane road with no bike lane or improved shoulder for him to move into. And so the only place that he could stop was in the lane. So for those reasons, the court should find him guilty.
All right. So you're saying that there is no proof that he knew what was in the Texas driver's handbook, and therefore that should be disregarded? The officer's testimony on with regards to the Texas driver's handbook?
The officer's testimony is not evidence that Mr. Davis.
No, that's what I'm saying. You're saying that there's no evidence that he knew about the rules for the Texas driver's handbook.
Correct.
And how is that relevant? Because the defense doesn't have to present any evidence, correct?
Correct. The defense does not need to present any evidence. But if the defense wants to rely on this DPS handbook for the proposition that Mr. Davis was obeying its advice, then there should be some evidence that he was at least aware of it, much less that he read it and that he obeyed it. And there's been no evidence.
All right. All right. The court has reviewed State's Exhibit number 1 in its entirety. I've heard both parties' argument. As both parties are aware, argument is not testimony, it's not the law. It's just your argument. After reviewing everything, listening to the testimony and seeing State's Exhibit number 1, the court will find the defendant not guilty. Is there anything else from either side?
Not from defense counsel.
Great, thank you. If you will give this to the court reporter, please.
Yes, Your Honor.
Thank you for dressing appropriately for court.
Thank you, Your Honor. That's
They would be excused, Your Honor.
Yes. Oh, and can I have the